Hello, everyone, and welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers, and this is another edition of Employment Law Q&A. Of course, we're here to take any and all questions when it comes to your workplace rights, when it comes to any issues you're dealing with in the workplace. This is the place to get those questions answered, to get some advice, get some information, and get moving on to resolving those workplace issues. As well, if you're dealing with a medical issue, if you are on a medical leave of absence from work and you're dealing with any kind of disability insurance issue, whether it's short-term or long-term disability insurance, by all means, ask away. We handle as part and parcel of a lot of our employment situations. We also handle disability insurance as well. These are very delicate situations, of course, when you're on medical leave, when you're dealing with health issues. Maybe it's even a medical accommodation in the workplace. Maybe your hours are restricted, or maybe there are certain things at work that you can and cannot do for medical reasons. Again, these are very delicate situations when it comes to the workplace. And perhaps quite interestingly, our laws are quite protective of employees when dealing with medical leaves and medical accommodations in the workplace. So again, any workplace issues whatsoever, any disability insurance issues whatsoever, this is the time, this is the place. Go ahead and post your question right now. If you're just tuning in, you're speaking with an employment lawyer and a disability insurance lawyer, what better time to get your questions answered? And again, get you moving on the way to making yourself feel a little better, a little better, resolving your situation, getting a sense of what options you have in any situation and what your best option may be. Do not be shy. Do not be bashful. There are no bad questions when it comes to employment law. And I promise I will be able to assist. It could be a very basic question about severance or about maybe pension. It could be anything, really. Any employment issues that you're dealing with, do not be shy. Go ahead and post your question right now. To get us started and get us a little warmed up, perhaps, when it comes to thinking employment law and thinking workplace rights for employees, there are a couple of matters I wanted to touch on before we get into the questions. But before we even do that, where should we start here? Well, I wanted to start with our contact information. Again, if you're dealing with a situation at work, if your employer is not treating you properly, or if you're dealing with any kind of disability insurance issue, please go ahead and contact us. There are numerous ways to do so. I'll perhaps start with the easiest, which is our website. Go ahead and visit our website right now. It's on the screen, employmentlawyer.ca. All one word, all lowercase, employmentlawyer.ca. It should be your starting point for seeking information, not only our contact information, of course, our phone number, address, all of that stuff, all of our lawyers and various offices. Of course, all of that is listed on our website. But we've also got a ton of resources that you can access on the website itself. Blogs, articles, video clips. We have employment law and disability insurance law essentials, basic information that any employee or any insured party should know about when they're dealing with these issues. I mean, it's simply a great resource for anybody that's just starting out and wants to get a sense of, what does my situation entail here? What am I dealing with? Am I dealing with a severance claim? Am I dealing with a constructive dismissal, which is a change to your terms of employment? Our website will give you a great initial primer on what those various employment issues may be. And of course, again, you've got our contact information there. For example, our email address. You can email us very simply at help@employmentlawyer.ca. That's help@employmentlawyer.ca. Go ahead and send us an email. Listen, keep it brief. Don't send us a 3 or 4 or 5 page email with every single detail of your employment history. We'll get into that during a conversation, perhaps. Send us a brief email. Give us a general description of the kind of situation that you're dealing with, some basic facts, and I guarantee you someone will get back to you if you email us at that email address. Of course, you can call us as well. Don't be shy to give us a call at the office. We have an entire team of intake people standing by to field questions to our office, answer basic questions, put you in touch with our lawyers. We are primed and ready to help anybody that contacts us in really whichever way we can. All right, so that's our contact information out of the way. Again, if your situation is a little complicated, perhaps, or it's very confidential, maybe you don't want to post the question online for that reason, please go ahead and contact us at the office. Do not be shy to do so. The initial contact is free, by the way, and so you can reach out to our intake team for absolutely free. There's no financial commitment by just calling, and then we could put you in touch with one of our employment lawyers, certainly if the matter requires urgent attention. All right, a couple of subjects I want to get the ball rolling with. And again, for those of you just tuning in a few minutes in, this is an employment law Q&A. My name is Alex Lucifero. I'm a lawyer specializing in employment law. This is a live Q&A, so I am here to answer any and all questions that come my way on whatever platform you're viewing this on. Please, if you're curious about a situation, again, maybe you just want to know what your severance entitlements might be. Maybe you're dealing with a bad boss, a boss that's not particularly nice to you. Give me a brief description in the question. You don't have to mention your company name. You don't have to provide any specifics. Ask the question in a very generic way. And I promise before the end of the segment, I will answer your question. And by the way, and our longtime listeners will know this, I answer these questions in quite a degree of detail. I will give you the rundown as to the way the law works, how it applies to your situation, and what the right thing to do in your situation is. So again, if you're looking for a good starting point and some good information on your particular situation, do not be shy to ask. You are in the right place. Now, very quickly as the questions line up, and I appreciate those of you who are starting to post them. Justina, thank you for your question. Arch M, that is excellent. I'd love to line up a few more here to give me a bit of a list of questions to go through. Before we get to the questions, very quickly, 2 points I want to touch on here. We're effectively in almost the middle of summer now, and if you're in Ontario at all, or if you're in really most parts of Canada, you're probably dealing with a bit of a heat wave at the moment. And this is something that has been posed of me earlier this week, and I wanted to address it here on the live stream. It should be an obvious point for most. Unfortunately, it isn't for some employers, and this is actually a matter that came across my desk this week. I had an employer in the construction industry treating its employees quite strictly, quite unfairly, making them work long hours with very little breaks in this kind of heat. And it raises an important employment law issue when it comes to health and safety in the workplace. Whether you are dealing with really normal working conditions or even adverse weather, such as extreme heat, even extreme cold, mind you, any really kind of difficult weather, it is very important to note our employment laws in Ontario, when it comes to health and safety of employees, is actually quite strict. When we are dealing with inclement weather and let's say extreme heat, your employer has to accommodate that kind of weather if you're working outside at all. If you're in the construction business, if you're in landscaping, if you're in any kind of manufacturing, perhaps there's no air conditioning in your workplace. These are situations that require an employer to get involved and accommodate employees given the climate, the environment that they're working in. For example, construction employees, and this is a matter again that happened this week. I spoke to an employee dealing with a boss that really didn't want to give them more water breaks and wanted to dock their pay as a result. Completely inappropriate on the part of an employer. Right? If you're dealing with this kind of heat and working outdoors, you should be able to take as many breaks as need be, whether they're water breaks or breaks in the shade. You should have equipment, right, that at least, hats, etc., that protect you from the sun. An employer has to respect and honor their commitment. And this is legislation, by the way. It's not just, me, Alex, saying this, right, because it's my personal opinion. Not at all. This is the way the law works. Employers have to respect health and safety in the workplace and the health and safety of their employees. If you're dealing with hot weather, extreme weather in the workplace, employees have a right to effectively accommodations as a result of that. I mean, these could be medical issues, right? You can suffer from heat stroke or dehydration. If you already have an underlying health issue, heat is obviously going to exacerbate those symptoms. And so do not be shy as an employee. Again, if you're in any one of these industries, and by the way, This can apply to other areas as well. I mean, I'm obviously talking about the weather, and obviously in this case, extreme heat, but this can apply to any other area when it comes to health and safety in the workplace. You have a right as an employee to demand that your workplace is safe, to demand that your medical restrictions or your health overall is respected. And by the way, that applies to your mental health as well. And so if you are in an overly difficult or overly stressful work environment, if you have a colleague or a manager that's mistreating you at work, I mean, that is a mental health issue. Of course, you have every right to demand from your employer that your health and your safety be respected. I wanted to remind our viewers and listeners of that because while it's an obvious point to some, it could be less obvious to some employees in certain industries. Again, imagine you're a construction employee. Maybe you're very young. Maybe this is your first job or it's a summer job. Maybe you're new to the country. Maybe you're a newer immigrant to Canada. You don't know the way employment law works in the country and in the province of Ontario. This is why we share this information for those of you that don't know the way the law works, for those of you that don't know what kind of rights and protections employees have in the circumstances. This is the reason why A, we do our job, but B, why we do these kinds of live streams and radio shows and TV shows, and why our job is to inform the public on what their workplace rights are. So, very important point that I wanted to raise, particularly given the week that we've had in terms of the weather and the extreme heat. Do not be shy if the heat has affected you at work to speak to your employer about what accommodations could be put in place to respect health and safety in the workplace. Second issue, very quickly, and this is phenomenal, guys. I see another few questions lined up, and perhaps just as a quick reminder, again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, LLP, partner with the firm as well. This is a live Q&A, so I'm not just here to talk about extreme weather and a couple of different cases that have come across my desk this week. I'm here to answer your questions. I'm here to answer questions live on the spot in the moment. It's what we do best. And a number of you have already posted a good amount of questions, so we're doing great. Guys, I'd already mentioned Justina and Bronto as well, Rishi as well, Peter as well, just about a minute ago. Thank you all so much for the question. I was going to mention quickly one more matter that came across my desk this week. I'll make this very quick, everyone, because I know you want me to get to the questions. And it is really the bread and butter of our work, and it's to do with severance. The reason why I want to mention severance is because, unfortunately, and this has been the case across 2024, really since the start of the year, we continue to see industry after industry, business after business, sector after sector implement layoffs at work. I think it's a sign of the economy. I think it's a sign of the times. It's difficult for everyone out there, difficult for individuals, for employees. It's difficult for employers and businesses as well. And what that means is restructurings, businesses shrinking, and unfortunately that means layoffs. And I will make this very quick because, again, we see this every day. We see this every week. If you are one of those individuals that are being impacted as a result of a restructuring or as a result of a layoff, it is extremely important not to sign severance documents on the spot. Your employer will sit you down for a meeting. They will tell you, unfortunately, we're having to let you go for X, Y, and Z reason. Here are some documents. Here's a letter. Here's the severance offer. They may even try and convince you to sign it. They may say it's a very reasonable offer. It's much more than the minimum that you would be entitled to. Do yourself a favor, whatever information you receive from your employer in a setting like that, if you're being sat down and being let go from your job, do not sign anything on the spot. I plead of you. Even if you think the offer is reasonable, even if there are a lot of zeros behind the number that's being offered to you as severance, do yourself a favor, say thank you very much, shake the person's hand, walk out with your head held high. Don't slam the door behind you, of course, whether that's figuratively or literally, if you're walking out of a workplace, right? And give us a call at the office. Make sure that the severance that you are being offered is reasonable. Severance could be very significant for employees. It's going to be based on your age, your position, and your years of service. The longer you've been with the company, the older you are, the more senior your position, the more severance is going to be for you. It's not going to be a week or 2 weeks per year of service. Severance could be as much as 24 months of pay. And that's not an overstatement or an exaggeration. 24 months of pay, particularly if you're a longer service employee, particularly if you're an older employee or in a management level or senior level position. Severance could really, really be that high. It can even be significant if you're a short-term employee. We see every single week, 6-month employees, 1-year employees, 2-year employees receive severance packages that are 3 months, 4 months, 5 months, 6 months of severance, right? That's how significant severance can be. The only point I wanted to make here, and it's a brief one, but it's an important one, because we do see employees just blindly accepting whatever severance the employer is prepared to offer. Don't do it. Don't sign on the spot. You have plenty of time to consult with one of our employment lawyers. Give us a call at the office. Send us an email at help@employmentlawyer.ca. Let us know that you've been let go. I guarantee you we will be able to put you in touch with one of our lawyers very quickly. That's it, guys. It's a quick piece of advice, but it is literally a piece of advice that can save you tens and tens of thousands of dollars, because that is oftentimes how much severance we see employees leaving on the table when they sign severance offers on the spot. And again, that is without exaggeration. It could be a difference of tens of thousands of dollars. All right, let us get to the good stuff, everyone. Again, this is a live Q&A. I am here to answer your questions. We have a number lined up. Thank you all so much for those of you that have posted your questions. First in line is Justina on LinkedIn. Justina says, great that you're doing live events. Just wish you and your team would pick up my inquiry for not being paid by a Canadian firm. I've been waiting since March. I have an employment contract that had not been honored by a Canadian company. I've submitted my details to your company and not one lawyer has called me. Justina, I'm so sorry. I think the reason might be if I take it that you're dealing with a Canadian company, but I'm assuming by saying that you might not be residing in Canada. And if you're not residing in Canada, Justina, then it may be that we're simply not able to help. We have offices, certainly we're Canadian, we have offices in the provinces of Ontario, British Columbia, and Alberta. And while we consist any employees that work and reside in those provinces, if you're residing elsewhere, so for example, Justina, if you're living in the US or the UK or really anywhere else in the world, and I just use those as examples, of course, your employment may be governed by the local laws of your state or your province or your territory, again, whichever country you are in. Just because it's a Canadian company, it doesn't necessarily mean that your employment is governed by the laws of Canada. And moreover, even if they might be, if you're not in one of those 3 provinces, unfortunately, we wouldn't be able to assist. That said, Justina, if I'm not painting the correct picture, and I'm obviously kind of assuming here on the basis of your brief comments, if you did reside in one of those provinces and you did also work there, listen, send us another email again. Someone should be getting back to you. If it's not one of our lawyers, it should be one of our intake staff. You can even find my email on our website and send me a quick email as well, and we can sort it out. I suspect that might be the issue. Feel free to contact us with some more details, but thanks for the question and for the support. All right, next up in line is Arch. Arch asks, good afternoon. When accepting a remote position for a US company, well, we've got lots of international questions today. Is there anything you should be aware of in regards to how their contracts may be different? It's a great question, Arch. I'm going to assume here that you're Canadian, and even more specifically that you reside in Ontario, and you're accepting a remote position for a US company. It's a very interesting question for a couple of different reasons, Arch. Number one, if you're working remotely for a US company and you're residing in Ontario, I think it's very likely the case that the terms of your employment should be governed by the local laws of Ontario. I say that because our laws in Canada, and in Ontario more specifically, are much more favorable to employees. They're much more protective of employees, as I've been saying over the course of the live stream. If the contract that you're looking at lays out different laws that apply, so there might be a line in the contract, Arch, that says, this contract is governed by the state of X or the laws of the state of X. Arch, that's a bit of a red flag. It's a bit of a red flag because obviously it inserts uncertainty as to what the proper legal jurisdiction is, right? Is it where you reside? Is it where you work? You're working remotely, so that it creates some degree of certainty. I should also add, and the reason for this concern is that employment laws in, I would say, almost every single state, if not every single state in the United States, is going to be far less protective of employees than our laws in Canada are. And so I think if that contract is governed by the laws of a particular state, odds are you're not going to be owed any severance if those law applies. Your employer, it is effectively what we call at will employment. And sometimes US contracts even refer to that employment is at will. Long story short, Arch, it basically means the company can do anything they want with you and you have absolutely no recourse as an employee. I hate to say it, but that's how employment law works in a lot of states in the United States of America. So, Arch, I'd be very careful about what you sign in terms of that remote work position. The enemy here is uncertainty. And so, whatever it is you're signing, you want to be crystal clear about what it is you're signing up for. If it's Ontario law that applies, great, excellent. You might also want to keep an eye on any termination language that might be in that contract. What happens if the company lets you go? Is there a certain amount of severance that's owed? Are they trying to limit your severance in any kind of way? I think the long and the short of it here, Arch, is that before you sign any kind of contract, right, and whether it's remote work or in-person work or et cetera, listen, it's probably worth your time and worth your money to have that employment contract reviewed. Give us a call at the office. We review employment contracts all the time, particularly if this is a specialized position, if they're going to be paying you well. Like I said, it's more than worth the money. And you might have some tips as to how you can protect yourself moving forward. All right, next up in line is Bronto. Bronto on YouTube asks, if you are let go from a seasonal position, mid-working season, what kind of severance entitlements do you have? Been with the company for 5 years. Bronto, excellent question. And it's a point that we actually raise often because it is one of the biggest myths when it comes to severance. A lot of people have the misunderstanding that seasonal employees, part-time employees, casual employees, students that are working and being paid by an employer, that these employees somehow aren't owed severance or that they're somehow owed less severance than full-time regular employees. And quite frankly, it's just nonsense. It's just not true. Bronto, despite the fact that you're a seasonal employee, if you have been working at this particular employer effectively season in, season out for the past 5 years, you're a 5-year employee. I mean, it's really as simple as that. Your severance is going to be based on that 5 years of service, your position within the company, and how old you are. And so I'd need to know your age and your position, quite frankly. But really, as a 5-year employee, and let's pretend it's a general laborer position because most seasonal work is. Listen, you might be anywhere in the range of kind of 4 to 6 months of severance, not weeks, Bronto, months of severance. That's significant, right? It's significant because, and especially you point out that you've been let go mid-season. Listen, it might be very difficult for an employee in those circumstances to bounce back into new employment, right? The season's already started. Let's say you're working in landscaping or you're working in construction. Most employers have already done their hiring for the season. They're fully staffed. They're ready to go. It might be difficult to find work, right? It might take you until next season to find work, and that's going to be a significant period of time. So the long and the short of it, Bronto, is that your severance entitlements might be significant despite the fact that you're a seasonal employee, particularly given that you've been let go mid-season. And that is ultimately because the purpose of severance is that it is meant to hold an employee over until they can find comparable employment, not just any employment, but employment similar to the employment that they were let go from. So if you've been let go, Bronto, and again, if you're in Ontario or Alberta or British Columbia in Canada, do yourself a favor. Give us a call at the office. Send us an email at help@employmentlawyer.ca. Again, I promise someone will get back to you. Let's figure out exactly what your severance entitlements are, and we can certainly assist you with that. I guess the good news in that respect is that severance is not a complicated legal issue. It's not a contentious legal issue. And so oftentimes, if not most of the time, we are able to resolve these situations quite easily, quite straightforwardly. All right. Where are we here? Rishi. Rishi is up next. Rishi says he was put on a temporary layoff with benefits due to business reasons. They didn't ask me to accept or deny. Can I continue using benefits in EI? My options? Question mark. What are Rishi's options when it comes to a temporary layoff? Rishi, it's another excellent question, a question we get all the time, of course. Here is the lowdown when it comes to temporary layoffs, everyone. Number one, and again, this is particularly the case in Ontario, guys. I'll speak with Ontario. I'll speak to Ontario employees specifically because that is the province that I'm licensed to practice in, and so this is where my expertise lies. Temporary layoffs are not necessarily or by default legal. An employer doesn't always have the right to force an employee to accept a temporary layoff. Actually, the opposite is true. The employee needs to agree to the layoff in order for it to be legal. Now, there are two ways in which an employee can agree to a temporary layoff. Number one, if it's written into your employment contract. Rishi, if you look at your offer letter or your employment contract with the company, and there's a paragraph in there that says the company is allowed to temporarily lay you off as need be, well, then I hate to say it, but unfortunately, they are allowed to temporarily lay you off. You can certainly continue your EI, you can certainly continue your health benefits, but there aren't really any options in the circumstances if it's in your employment contract, right? Alternatively, if temporary layoffs are already a term of your employment, kind of implicitly, meaning, and like Bronto was saying, if you're a seasonal employee and you're laid off every winter, right? Or if you've been laid off before by the company, and this is just one more temporary layoff in what's been a string of temporary layoffs over the course of your career with this company, right? Well, then simply practically, even though it might not be in your employment contract, right, the company may rely on the past layoffs to be able to lay you off again. Now, here's where things get interesting, Rishi. If temporary layoffs are not a term of your employment contract, if there's no contract in place, or if there's nothing in your employment contract about temporary layoffs, or if you've never been laid off before, you have the right to treat this temporary layoff as a permanent termination, in which case you would be owed severance based on your age, position, and years of service. I can tell you, Rishi, that most of the time, treating a temporary layoff as a permanent termination is going to be in your best interest. And it's for the reason that I just mentioned, which is that if you accept this layoff, Rishi, guess what? 2 months from now, when they call you back, or a year from now, when they try and do this again, they will be able to implement temporary layoffs moving forward into the future, and you won't have any options at that point in time. So, in other words, you have to contest the first time you're temporarily laid off. And the way you do that is to say, you know what, guys, I'm not accepting the temporary layoff. I'm going to treat this as a termination and receive severance. It's going to be by far your better play, get you moving on to new employment that's not going to involve temporary layoffs. Rishi, before you tell your employer anything, if you're in Ontario, if you're in Alberta, if you're in British Columbia, do yourself a favor, give us a call at the office, right? Visit our website, employmentlawyer.ca, email us, however you want to get a hold of us. Let's have a quick chat first. I want to review your employment contract. I want to have a quick chat with you. Odds are we'll be able to assist here and get you your severance entitlements, and again, get you moving on to new employment. All right, let's keep it moving. We'll do a couple of rapid fire questions here, guys, because we're up against the clock. Peter was not next up in line, and he asks, would someone be entitled to severance for management micromanaging and making life slash work difficult, and you left for a new job by choice? How would I go about proving micromanagement and workplace? I imagine you might mean workplace harassment, Peter. Excellent question, difficult question. It's a question of degree. Peter, how bad was this behavior? How bad was this treatment? If it was simply a manager that was maybe a little pushy, maybe a touch inappropriate, right, that might not rise to the level of what we call a constructive dismissal. Constructive dismissal is effectively a breach of contract. If an employer does something inappropriate or terribly wrong, right, or makes a major change to your employment, that would allow the employee to leave their employment, as you did, and seek severance. If the behavior was obscene, Peter, and abhorrent, and very obviously inappropriate, and very obviously, creating a poisoned work environment and a breach of your employment rights, well, then that would very obviously be a constructive dismissal. So these are where things get interesting, Peter, because it's about what you can prove, what you can't prove. Again, the degree of unprofessionalism or micromanaging or of workplace harassment that can be established. The only way to figure that out, Peter, is by having a conversation with one of our lawyers. If you're curious about this, I would not let it go, by the way. The sooner you deal with these matters, the more likely that we would be able to act. Don't sit on this. If this just happened, effectively, you want to get advice right away. We will leave it at that today, folks. I know a couple of you had posted some additional questions. My apologies for not getting them answered. The good news in that respect, we have another Q&A coming up tomorrow. Tune in at 1 p.m. Eastern Time. My friend and colleague Thielen will be answering any and all questions, just as I did today. If I didn't get to your question today, tune in tomorrow. Post your question. Copy paste the question. And I promise Thielen will answer it, and he will answer it appropriately. Until then, everyone, wishing you all a good rest of the day, wishing you all a good rest of the week and weekend. Take care, and so long.